Celia Edwards, Queen Counsel, head of Chambers of the Law Office Judge E.D. Klein, claimed a victory against Janin Caribbean Construction in the Privy Council, the highest court of appeal for Grenada. The case started in 1993 when a workman with Janin Construction sustained injuries on the job. The worker sued Janin on a date fixed for the trial. Janin did not show up in the court. In their absence, a judgment was made against the company. In turn, the company sued the authority for professional negligence. The matter was dismissed in the High Court, further appealed and dismissed in the Court of Appeal, and finally taken to the Privy Council, where today the final dismissal was given. Ms. Edwards, representing the law firm in this case, Wilkinsons, spoke of the victory.
I defended the Wilkinsons. We were successful in the High Court on the basis, one, not only was there no negligence, but as a barrister, Mr. Wilkinson was immune from suit while he was acting as advocate. Janin was dissatisfied and appealed to the Court of Appeal. They lost there also, and appealed to the Privy Council. We were then forced to travel to England in June to defend the Wilkinsons before the Privy Council. The judgment was handed down today. The Wilkinsons were successful on the very ground that I had raised in the court below at first instance, that a barrister, when acting as advocate, is immune from suit for professional negligence. That is Janin's last record. There is no other court to which they could appeal. That is the end of the matter.
She further elaborated on the principles of immunity.
What it does is that it reaffirms that our law does not have to be the same law as England. England has a different law to us on the issue of immunity, because in a subsequent case in England, they ruled that the public policy considerations which founded that principle no longer applied in England. But our courts have decided they still apply to us. The principle is still relevant, and the court and the Privy Council today upheld the principle that that is the law of Grenada, and as a consequence of the OECS.
Moving from the Privy Council to the CCJ is one of the bills presented for referendum. Ms. Edwards says the Privy Council supports the claim the Bar Association has been making for the move to the CCJ.
This very judgment handed down today, the Privy Council reaffirmed a principle that they had established long ago, that in respect of policy matters and practice, our courts are in the best position to determine what the law is on that. As a matter of fact, on one area of holding papers for an adjournment, the Privy Council said that they were not even going to adjudicate on that. There was no need to adjudicate on it, one, because of the immunity, but two, they were not going to adjudicate on it because they were not familiar with the practice, and our courts are more familiar with it. What that says is there are some practices and customs that we have that are totally alien to the Privy Council, and we have the competence in the Caribbean. We have the competence, we have the expertise, and it is time for us to recognize that.
Ms. Klein is pleased that in this instance, justice has been served. Renee Toussaint, GBN News.